no longer the case that you can just issue a casual cookie-cutter contract of employment and hope that you're protected. It's going to take a little bit more.
Welcome to the Business Behind Your Business, conversations to help your business grow and thrive. Hi, I'm Paul Sweeney, founder of Cripps Solutions, chartered accountants and certified business advisors, hosting the Business Behind Your Business. Welcome to the Business Behind Your Business podcast. And today we're going to be following up on a subject that we've already had some discussion on back in episode 24, back in February 2021, where we were talking with Philip van der Heever and Paul Cripps about changes to the landscape regarding casual employment. And we talked about what was on the pipeline and mentioned that there were going to be some changes on their way in response to some court cases and changes to casual employment conditions. Now, my understanding is that those changes have now become law and are now going to be in effect. So what does that mean for you as an employer, as a business owner? What does that mean? And I'm an accountant, so I have not got the background to tell you what's going to happen. So I've brought back into the studio Paul Cripps from PK People Solutions. And I also have Ben Baumgarten from Frank Law, who's an employment law specialist. So these guys are going to help unpack what those changes mean for employers and give you some guidance about what you need to be doing in respect of your casual employees from now on. So, Paul, welcome back to the podcast.
Thank you, Paul. Good to be back here again, and good to, I guess, probably follow on to the episode 24 to give a real good update to the people that subscribe to the podcast.
Mm-hmm. So it seems like such a long time ago, but things move very quickly, and they have moved quickly. So, Ben, this is your first time joining us on the podcast from Frank Law. Would you want just to give us a bit of background about your experience?
Yeah, sure. Well, thanks for the invitation, Paul. I'm really glad to be here today and to speak about what's happened with the changes to the Fair Work Act in terms of casual employment. My experience is I'm a solicitor and I've exclusively practiced in employment law with a focus on employers. So that's really the market that I cater to, and particularly with small to medium-sized enterprises as well.
Well, that's exactly who's going to be listening to us today. So that's a perfect match there. So, look, before we go and talk about what's going to be the impact of the changes, we might just recap what the change actually is. So, Paul, would you like to give us a bit of a summary on what's going on?
Yes, look, certainly. If I sort of probably kick off, and Ben can chip in because that's the way this works well. Necessary when I sort of perhaps get some of the nitty detail, the technicalities correct. But effectively, we had a legal case that had been bubbling around for a couple of years, waiting for a final conclusion. And it really this outcome, I think, is actually a good news story for employers. Because the limbo that we were sort of left in was that there was an opportunity potentially for an employee to double dip, and we had an employee, Mr. Rosato, as part of this case, he was paid a casual loading, and then down the track claimed kind of entitlements for leave. So this new ruling that came out on the 27th of March gives some certainty, thankfully, to employers. And we're currently in a 6-month transition period. So basically, the listeners to the podcast shouldn't worry they've missed the boat. There is still time to take action. Although, as we see, the 27th of March is almost 3 months from now, or 3 months away. So the 27th of September, which is a deadline to make some changes, is rapidly approaching. But and what we'll do in this podcast, myself and Ben will run through what it actually means for employers, and I'm happy to run through some of the examples of what I've heard so far from some of my clients and connections.
Yeah, that's great. So Ben, what exactly is the change going to be?
Yeah, so what's occurred, and some of the listeners might be aware that back in November last year, what was called, the long title is called the Fair Work Amendment, Supporting Australia's Jobs and Economic Recovery Bill 2020, and it goes by the other alias as the IR Omnibus Bill. It was introduced as a bill into Parliament, and it was a very large bill, included other aspects other than casual employment to do with unions as well. A lot of the detail of that bill was stripped out, and what made it through, and lucky for us, was the aspects in relation to casual employment, and amendments were subsequently made to the Fair Work Act on the 27th of March this year. So the changes that have occurred is that, I guess the main change now is that there's a statutory definition of casual employment in the Fair Work Act, and that's under Section 15A. And there's also guidelines, I guess you could refer them to, in respect to converting casual employees into permanent staff. And there's also the statutory set-off provisions under Section 545A that have been inserted into the Fair Work Act. So there's been a lot of changes that have happened in terms of casual employment over the last couple of months. There's also some other little changes there about, if you might have a dispute about converting a casual employee, there's pathways now into the Fair Work Commission where you can, have that issue disputed.
So just clarifying, so a casual employee, one of the things that we had in place for casual employees, because they worked irregular and not guaranteed hours, they were paid a loading. So it was 20% loading above the normal pay rate to compensate them for not having entitlements to annual leave and personal and carers leave. But this court case decided when the payment was made that he was actually entitled to leave on his accrued service, because effectively he was a permanent employee. But we have this dilemma because he was being paid as a casual with a loading, and then the decision was made he was a permanent and he was entitled to leave. But if he's entitled to leave, he should not have been getting the loading. And this is, I think, where one of those issues came out. So the guidance in that you just mentioned in the Fair Work Act is that to help employers go through that situation where you're paying an employee on a casual basis, and now you need to change them to a permanent basis with leave entitlements. Yeah.
So the way that the Fair Work Act's been amended to help those situations is that you now have a set-off clause which is 545A of the Fair Work Act. I'm sorry if I mention legislation a lot, but I'm a bit of a law nerd. So I like saying these things.
You need that.
Yeah. But basically what happens now is that when you have a casual contract of employment, what you should be doing is actually stipulating the loading. So you might say that for a casual employee, the base rate might be $25, and then you would say, and then on top of that, there's $30. I'm just throwing figures out here of loading, which represents the casual loading of that pay rate. And then you might even go further and break down that casual loading rate and say that of that $30, $10 relates to annual leave, $10 relates to personal leave, and there might be another rate there for leave loading. And the benefit of doing that is that if it's over disputed, if a casual say, well, I was a permanent employee, I became that type of employee over the course of my employment, the employer can now, I guess, set off those entitlements that casual employee might be owed by saying, well, actually, I paid you a casual loaded rate, and these are the components, and the court can actually drill down. So let's say like the casual employee said, well, you owe me X amount in annual leave, and the court can drill down and say, well, you've actually been paid your annual leave as part of your loaded casual rate. So that's the benefit of that set-off clause. That wasn't available to employers, I should say, previously, and it's retrospective. So that set-off clause can be applied to historical claims from casual employees.
And I think that's a really important point, Ben, because I think that, certainly I think that's something that's really helpful for employers, and it's a good news story for employers. And the correct drafting of those clauses is one of the things that I see as being absolutely key, because it's having the correct drafting of the clause, plus then, as you say, the breakdown how an hourly rate is made up. Will be the thing that which, if there is a claim down the track for these benefits, that will be something that will work in the favour of the employer in being able to defend any of those kind of claims. So there is work to do. For this is not a free gift for employers. There is some work they need to do, but it's going to be helpful for them if ever they face issues down the track.
So I'm guessing from what we're saying here that if you're converting somebody from a casual to a permanent part-time basis from this point on, as an employer, you're not having to accrue for past leave entitlements, because the loading that you paid will have factored that in. That's why the loading was there. But now, Ben, you mentioned specifying the components of that loading. My guess is that no employer has had that incorporated into the historical agreement. So where do we stand on that position?
Well, there might be some hurdles that employer might need to jump through to offset any entitlement, like an entitlement claim that might be made against that employer. So it's really critical that looking forward that now is time to clean the house, so to speak, and to get your contracts of employment to a suitable standard, because previously there might be some exposure to entitlement claims.
And I guess the thing is, Ben, is at the moment, I guess there's no legal test, there's no test cases, is there? So
that's right.
There is, we're very much in that territory of, that there is good action to take going forward. Anything historical, I suppose you could argue, could be up for debate. But certainly there's no harm. A lot of employers would already have some, and I think as Philip mentioned last time, hopefully have got some kind of offset clauses already drafted. Certainly, I've seen better clauses drafted now. We have the legislation, and I think that's the important thing. I think for as Ben says, to go forward, it's important here.
Yeah, like a set of clauses over the last few years have been, I guess, in my view, a commonplace in contracts of employment. I guess that next level now is that, considering we've got some clarity around double dipping and a set-off clause in the Fair Work Act, it puts the onus on employers to really make sure that the contract of employment, particularly in the way that the casual loading rate is expressed, is very clear. So, look, it's going to take a little bit of getting used to, a little bit more time to draft those contracts. And look, I'll put my hand up. I can help you with that if you like. But it's no longer the case that you can just issue a casual cookie cutter contract of employment and hope that you're protected. It's going to take a little bit more work.
So does this apply to every employer, or is there a carve out for small employers?
It applies to, in terms of converting casual employees to a permanent position, the way that they've termed it in the Fair Work Act is a non-small business employer doesn't have to offer conversion to a casual employee to a permanent position, even if that employee has 12 months service, and at least 12 months service and 6 months of that has been like a regular pattern of work. for a small business doesn't have to. A non-small business has this obligation after they've had a casual employee for 12 months and the last 6 months of that engagement has been a sort of a regular pattern and it's likely to go on. So that's the obligations now upon your non-small business employer.
And I might actually just add something in there, just because I had a real life example, because I had a client that was very hot to move on this, and very up on what was going on, and this particular example was when we talk about small business employees, because their example was that they actually they failed the test for small business because whilst they had I think it was something like 13 employees in Australia, they were part of an international organisation.
Yes,
so
associated entity.
That's right, exactly right. So, and we knew that up front, so that wasn't a bad news story for them, and they wanted to do the right thing. But it is something that could catch some employers out that may feel that they don't need to take any action. But obviously, with the and Ben, the correct definition, please, is associated overseas entity.
Yes, and the meaning is or associated entity. The Fair Work Act takes the same meaning from Section 50 AAA or AAA from the Corporations Act. So it really comes down to control. So if, for example, if the parent company controls the subsidiary in Australia, if it controls its material affairs, then more often than not, they're going to be an associated entity, and those employees get pulled. That's the same situation in redundancies, and going off on a tangent here, it's the same concept. So something that Paul, you quite rightly pointed out. If you have other businesses, it doesn't need to be the same type of business. You could own a mower shop in Castle Hill, and I need to go. I've said that because I need to get some parts for my mower on the weekends. But and you could own a pizza shop, and you could have control both businesses, and all of a sudden you've got more than 14 employees, and you've got some obligations in terms of converting your casuals or offering conversion.
So just to clarify, because the definition of a small business seems to be different for every piece of legislation, what's the definition of a small business for this casual employee conversion?
Well, I think it's adopting the definition of small business that's in the Fair Work Act, which means that if you have less than 15 employees, then you're a small business employer. So that's really, you've got up to 14 employees.
And that's headcount, not full-time equivalent. Is that correct?
Yeah, that's headcount. So that would be your full-time, part-time, and any regular and systematic casuals are usually included in that amount. If you've got contractors and people like that, they're outside of that count of employees.
Okay. Oh, that's good. That's good. So are we still going to have casual employees?
Well, look, I think we will, and there's a statutory definition in the Act now that makes it really clear what is a casual employee and what isn't a casual employee. And at the start of the podcast, I think I mentioned Section 15A. So really, for me, this is where everything kind of stems from. This is the most important change that's been made to the Fair Work Act. And the way that the Fair Work Act now defines a casual employee, and I'll read it out, it's where an offer of employment, and it says a person is a casual employee of an employer if an offer of employment made by the employer to the person is made on the basis that the employer makes no firm advance commitment to continuing and indefinite work according to an agreed pattern of work for the person, and that person accepts the offer on that basis, and the person is an employee as a result of that acceptance. So what does that what does that mean? So it means that what's important now is to deem someone a casual employment. It's got everything to do with the offer that's made to the employee at the start of that employment engagement. So if somebody comes in for an interview and you're wanting that person to be a casual employee, then you're basically offering to that employee no firm advance commitment of shifts. So really that would be, we're going to engage you on a needs basis. And there's no agreed pattern of work. The benefit of that is that if you have a casual employee and they morph into a part-time employee through conduct over that employment engagement, that doesn't matter anymore. That's what caught out a lot of employers in the past, that you had these casuals who then became regular and systematic casuals. And then a step further, they might be owed part-time or full-time entitlements. All that matters now is that at the start of the employment engagement, you agreed that there's no firm advance commitment of work to that employee. So, and it's even legislated that it doesn't really matter, what if that employee or that casual employee, through the conduct of the employer, starts to sort of take the character of a part-time employee. It's what's important is what's agreed to at the start of the employment engagement.
So we've talked about, I guess, the legislation and what the facts are, but from a practical point of view, you're going to have employees in a small business employer where there's still going to be that conflict of casual versus part-time. So what are some practical ways that you'd recommend, particularly Paul, you'd recommend employers handle the negotiation with, or the information with employees?
Yeah, look, I think that's something which myself and Ben can cover off together. I think that looking for a small, let's take a small business employer first of all. Is that there, as Ben said, there is no obligation on the employer to review existing casuals, but a casual that works for that an employer can request permanent employment, and the emphasis there is for the employer to look through the pattern of work, as Ben says, over the past 6 months, in terms of is the kind of pattern on hours of work over the next 6 months, is that something that could be permanent part-time or potentially even permanent full-time as well. Depends on what sort of hours and pattern. And look, then it's down to the employer that needs to make a decision. Well, is that in place? And then in terms of whether the employer needs to consider an offer of employment, there are grounds on which an employer can refuse, and other than the fact there hasn't been a regular pattern, and generally that's down to the role that's there at the moment may not exist within the next 12 months, or the hours could be reducing, and I think that, Ben, the word that they Fair Work offering us, or any other reasonable grounds, is usually one that's thrown in on everything. What that actually means in practice for us at the moment, we don't know, but it's always that get out clause that they like to use. But so I think those are really probably the tips I'd say is look at the pattern of work, about what that looks like. And when I say that, I'd say look for each week. Look at the hours of each week. I had the first client that I had that went through this. First of all, they just gave me a summary of their average hours over a period of 6 months. I said, no, we need to go week to week and look at each week in terms of what the hours were, what was that pattern. Even going as far as start and finish times. Now, maybe Ben, was a bit too thorough there. I don't know, but I thought let's be thorough on this to try and make sure that we're coming to the right outcome here. And look, I think it's that's what I'd say in terms of looking at doing the assessment and then think about, are there grounds to why an employer can say no? Because there is an option for that, definitely.
So just wrapping up a bit, but I guess one of the key things is if an employer doesn't act and doesn't get these agreements in place, what's the implication for them?
Well, I suppose if they don't take action, you see, this legislation is very much, as I said before, it's a good news stories for employers. So what they can do, there's a couple of things where they get caught out, and I'll let Ben help me with any others that I may forget here. But certainly one of them is that what Ben's already described is that they could have a casual employee down the track that tries to make this double claim if they've not got their contracts right, and they're basically how their hourly rate is broken down correct, and also if they're if they're not taking action when an employee when a casual employee requests that there's an assessment done. I mean, look, what the penalty will be, well, we don't know at the moment what might apply, but certainly that's something which a small business employer still needs to look at that, and probably a really simple, obvious thing as well, which is also a bit of a prompt for all employers for small business or otherwise, is to give out what I call Exhibit A, which is not going to work on a podcast, but Exhibit A is the casual employment information statement that got released, and it's not just releasing; it's understanding. Employers need to understand actually what's in there as well and what it means. So purely just issuing out that statement alone is not going to be helpful. But there is an obligation, isn't there? Is that right, Ben? For that employers should be making sure that they're actually giving this out to casual employees on the go forward.
Yes. So small business employers have an obligation to give that out to existing and new employers now. So that form needs to be given now to your employees, to your casual employees. For your non-small business employer, on or after the 27th of September, that's casual information statements. I think I've mispronounced that long term, but it needs to be, basically short story is 27th of September.
So we've got some timeframes that you have to comply with. And
that's right.
Look, these things are meant to be simple, but sometimes they are not. So, as always, we recommend that if you're not sure about anything, that you should get advice from the right people, the right kind of people, and this is where your HR professionals and your employment lawyers are the guys to go to. So we'll put some links in the show notes, particularly to that casual employment information sheet from Fair Work Australia, and also some contact details for Paul and Ben. But Paul, if people are listening and want to get in touch with you, what's the best way?
Yes, look, email's fine. Email address is paul@pkpeoplesolutions.com.au. It's always the best way to get hold of me. So that'll be the way to do it.
Great, fantastic. And Ben, what's the best way for people to reach out to you?
So two ways, either through email or telephone. And I'll give my email address out. I do have a long surname, so bear with me. So it's initial B. B for Bob, and then it's my surname, which is BAUM, and for Mary, GARTEN, and for Nelly. So that's B Baumgarten @franklaw.com.au. If you'd like to get in contact with me through telephone, it's 029688 6023.
Fantastic. Look, we'll put that information in the show notes. And other ways that you can keep in touch with us is through, subscribing to our newsletter, which is going to be a new feature. And in that, we're going to recap the month's episodes and discussions and provide some extra resources that may have been mentioned or discussed during the presentations or the discussions. And there might be there's some more to come on this, I believe. So I know that Ben's going to be putting out some more information in the future. So we'll put some links to that in those newsletters. So if you want to subscribe, look out for www.thebusinessbehindyourbusiness.com. And if you've got any specific questions as a business owner or somebody considering a business and you want to speak to us and ask us a question directly, then you can go to speakpipe.com/the business behind your business, And you can leave your question in an audio format and we'll feature that on one of our upcoming episodes. So plenty of ways to keep in touch with us. To make sure you don't miss any future episodes, make sure you follow us in your favourite podcast player, whichever one that is, Apple or Spotify or Stitcher or all of the main podcast players, and even the other ones. We're listed on pretty much every podcast player that you can find. So you've got no excuse for not finding us where you listen to podcasts. So thank you again, Paul and Ben. It's been great to sort of unwrap and get some clarity. And as you said, Paul, it is a good news story for employers. Thanks for listening. Do you have a question you'd like our team of experts to answer? If you do, send your question to podcast@thebusinessbehindyourbusiness.com. To hear more from The Business Behind Your Business, don't forget to subscribe using your favourite podcast player. Or you can visit the businessbehindyourbusiness.com website.